A couple of the questions put to Robert at the end of his very interesting and insightful talk are, I think, a fairly useful starting point for what I wish to address. Firstly, is there any case law in South Africa which tends to support his position? Well, I think not, but I haven't made a study to determine whether or not that is the case. However, the paucity of case law, or perhaps the complete absence thereof, is no indication whatsoever of whether the points that have been raised and whether the very compelling argument that is put forward is any the weaker on that account. I believe that what has happened in South Africa ever since the commencement of the constitutional era is that the Constitution has taken precedence over everything else, including the rule of law, and that all issues of fundamental rights, all issues that come back to the issue of whether the state is acting or whether an authority is acting beyond the authority which is conferred upon it by the law, is inevitably and instinctively answered by reference to the Constitution. And in this regard, my impression is, and I think my impression is right, that the principle of the rule of law has received very little and, in fact, no attention whatsoever. This doesn't mean that there's any less legitimacy in the argument that has been put forward. It only means that it is an issue that has been all but ignored during the course of the constitutional era for what are perhaps seen to be legitimate reasons. Among other things, one may say that courts deal more easily with the written document, which is the Constitution, and indeed practitioners deal more easily with the written document, which is the Constitution, than they do with a more abstract legal concept which actually pre-exists the Constitution and has done so by several centuries, but which is less easily discernible and less easily conveyed to a tribunal, and indeed even to the Constitutional Court. So there's been a bias in favor of constitutional jurisprudence and perhaps even a bias against rule of law jurisprudence. That doesn't mean that there's any the less legitimacy in the latter. The other question that was raised was, well, not so much a question, but it was an issue that was alluded to by Robert, and that is the fact that other constitutions around the world have not incorporated the rule of law into their language. Well, that's also not entirely surprising. In fact, perhaps the most surprising thing of all is that the South African Constitution chose to incorporate the rule of law into the Constitution. And this may very well be on account of the attempted distance that the constitutionalists, the writers of the Constitution, wanted to put between the new dispensation and that which had gone before. The rule of law was very frequently violated and very fundamentally violated under the old dispensation, which doesn't mean that it wasn't part of the common law of South Africa, even at that time. Even during the apartheid era, the rule of law was part of the South African common law, but was very often and most frequently and scandalously ignored both by the legislature and by the courts. This doesn't, again, detract in any way at all from the force and the authority of the rule of law. Now, the rule of law has its origin, as I say, from many centuries before any form of constitutionalism existed. And the modern form of constitutionalism originated with the Enlightenment, and in particular with that liberal thinker, John Locke, who expressed the liberal triad as life, liberty, and property. The principal author of the American Declaration of Independence, for whom I have great admiration, Thomas Jefferson, was, however, somewhat more circumspect in this regard. And he replaced the requirement of property with the pursuit of happiness. Well, that is very unfortunate from a variety of points of view, because the pursuit of happiness is an illusory and an elusive quality. It is something that I suppose people tend to try to pursue, but it is very seldom ever achieved. And the idea that a whole people, an entire nation, can single-mindedly pursue happiness as one of the founding principles of their republic is, I think, an illusion of the highest order. Fortunately, there's been more sensible counsel since Thomas Jefferson, and this has come in the person of a notable liberal and libertarian writer by the name of Murray Rothbard, who described the liberated individual as one who possesses self-ownership. Now, that makes perfect sense, in fact, because ownership of the self goes hand in hand with the concept of being free of authority, of being free of a subversive authority which supervenes and overcomes any of the liberties that you may wish to enjoy. So he understood that self-ownership was of the essence to the principle of the liberated individual, and he went on to say, a person who possesses self-ownership possesses, of course, also the fruits of everything that he does. He may not in unfair way be discriminated against, he may not in unfair way be interfered with, and he's entitled to do whatever he chooses to do, whether it be good for him or bad for him, provided only that he does not in this way interfere with the equivalent rights of others. That is the classical definition of the liberated individual and of the liberal tradition. So the property right is an essential part of the liberal tradition, and it is an essential part of somebody who professes to hold dear the principle of liberalism and of freedom of the individual and freedom of thought and freedom of association. All of those things go together with the right to use your time, to make of your time what you will, and to use it in whatever way you choose to do, provided only that you do not in this way interfere with others in an unreasonable way. It follows, therefore, that anything that one acquires as a result of the exercise of this freedom must also adhere to the person, because the person who possesses self-ownership possesses also, obviously, the fruits of his labor. And the fruits of his labor accumulated over time is represented by property. So the two are essentially inseparable. One cannot in any way, notionally or morally or in any other way, distinguish between the right of freedom of the liberated individual on the one hand, and the right to do with your time what you choose to do, and the right to accumulate whatever you may or may not manage to accumulate during the course of a period of time or during the course of a lifetime. Those things belong to the person. It is part and an essential part of that liberated individual. A more recent source of the same wisdom comes from the renowned historian and scholar Neil Ferguson. In his book, Civilization, the West and the Rest, he said the following: "Indeed, it was the idea that made the crucial difference between British and Iberian America, an idea about how people should govern themselves. Some people make the mistake of calling the idea democracy and imagining that any country can adopt it merely by holding elections. In reality, democracy was the capstone of an edifice that had its foundation in the rule of law. To be precise, the sanctity of individual freedom and the security of private property rights ensured by representative constitutional government." So those in fact, that's a clear encapsulation of the idea previously enunciated by Murray Rothbard when he said that it is altogether dependent upon the right to self-ownership. And as Ferguson has noted, the rule of law was the source and not the consequence of the liberating influences that were derived from the Enlightenment. Well, that much is evident, because even on the most conservative basis, the rule of law had its origin in 1215. But on a slightly more expansive basis, a somewhat more expansive basis, the rule of law can be traced back to the rule of Hammurabi of Babylon in the year 1750, when he published his famous law code. Now, parts of that law code are still in existence, and there's part of the preamble that is to be seen in the Louvre in Paris. Hammurabi, in his preface to his law code, made this observation, and I'm not quoting verbatim, but it's approximately correct. He says, "And then Abu and Bel, both gods, address by name me, Hammurabi, the exalted prince, and called upon me to bring about the rule of righteousness in the land, to punish the wicked and to support the weak. Words to that effect were the words of Hammurabi. And as a result of this injunction, it might have come to him in a dream, or it might have come to him in a state of heightened delusion. But the fact of the matter is that this is what Hammurabi said was the cause of his having published his law code. And what is evident from this piece of historical data is that Hammurabi, as the ruler of Babylon at the time, recognized a source for the authority of his rule outside of himself, beyond himself, pre-existing himself, and authoritative over himself. Hammurabi didn't then go along and say, well, please, gods Anu and Bel, inform me about precisely what laws I must go about enacting. He enacted the laws according to his own wisdom, in accordance with the idea of what he thought to be the rule of righteousness. But one thing that is clear is that the rule of wickedness is not the rule of righteousness. And Hammurabi, who believed superstitiously or otherwise in the authority of the gods, would surely have been very cautious not to disobey the fundamental injunction that was given to him by the gods, and that was that he was to bring about the rule of righteousness in the land. Now that is essentially another way of describing the rule of law. The rule of law in this case were two gods who gave Hammurabi an instruction, and an instruction which was obeyed by Hammurabi, and which quite evidently would have been fervently looked into and protected during the course of his reign, because he knew that he had a sacred trust with the gods. This is the equivalent, really, of the rule of law. The rule of law is there as the supervening, as a super authority over all law, including the Constitution. The Constitution itself is a derivation from concepts that are already ages before the Constitution, in the form of the rule of law. Now, the world justice. There's one other thing that I need to say. The right to gainful employment, which I've alluded to earlier, and the consequent right to accumulate the fruits of one's efforts are obviously part of this right to the liberated individual. And the right to hold private property and to defend that right against the world, as it is said in the Roman law, is categorized as a real right within the Roman Dutch common law. So the Roman Dutch common law already recognized that you had the right to acquire your property and you had the right to defend that property against the world. Well, now, who is the world? Who would the world be against whom you would require protection, or against whom you would be entitled to protect your right to your property? Well, in the first instance, it would obviously be thieves and looters and such like. In that regard, you were even given the right to self-help by the Roman Dutch law. You could actually pursue the thief and, if need be, overcome him with violence in order to retrieve your property. Those are things that you could do, and the law would justify such violence in those circumstances. But more predominantly, the party against whom the violation of property rights has to be protected is not the thief. It's not the robber who comes in the dark of night to deprive you of your television set. It is the state. The state is the predominant threat to the right of property. And that is the right which the Roman Dutch law recognized as a right which the individual has to protect against the whole world, including the state. You have that right to protect the right to your property even against the state, against incursions by the state. The World Justice Project has also categorized the right to hold private property as a subset of the rule of law. Now, there are innumerable jurists and philosophers who equate liberty with the right to hold property unmolested, and both with the rule of law. If one sees the rule of law as a barrier that the law sets against tyranny, it becomes evident that where liberty and property are coexistent with the rule of law, any systemic violation of either must of necessity involve an element of state coercion and therefore a violation of the rule of law. It follows axiomatically that a state violation of your right to your property, which is not sanctioned by the law, is a violation of the rule of law. Now, I want to deal for just a moment with the Agri-SA case, which was alluded to this morning by Anthea, and this concept of custodianship, which seems to have started to preoccupy the compilers of the legislation on this issue. They seem to think that there's now an open sesame upon the issue of expropriation and expropriation without compensation, provided only that the expropriating authority takes the property not as owner but as custodian. That's the trick. In fact, it's, to my way of thinking, a fatuous argument, because every transfer of property, every transfer that occurs lawfully of property involves a bilateral transaction, at least a bilateral transaction, if not perhaps a tri- or a quadrilateral transaction. On the one hand, you've got the acquirer, the party who acquires the land or acquires the property. Now, in this case, the Constitutional Court perceived that party in these circumstances, and the circumstances that prevailed in that case, as not taking ownership but taking custodianship. And this was the trick. It was an intellectual trick, quite frankly, which was I think quite unfortunate in the circumstances, because that was a case of looking at only one side of the transaction, of the transfer of ownership. If you look only at the acquirer, at how the acquirer acquires a property, he can acquire it, I suppose, by violence or by subterfuge or by trickery or by employing the law in a dishonourable fashion. All of these are various ways in which the right of ownership or the right to possession of property becomes manifest in one form or another. However, the other part of the bilateral transaction is the deprivation of property on the other side. The party who heretofore was the owner of the property is deprived of something. And that was the side of the transaction that the Constitutional Court didn't even bother to look at. Well, I think, frankly, it's scandalous, because it looked at one side of the transaction, what is the state acquiring, without bothering to inquire into what was the owner losing. And you can't legitimately, in a considered judicial opinion, look at only one side of the transaction and then conclude on the basis of your one-sided evaluation of this matter that ownership is not being acquired, when in fact it's plain that ownership is being lost. You cannot ignore that second part of the transaction. So, in my view, the Agri-SA case is deficient in various ways, but most fundamentally in this way. And I don't know whether that was an issue that was raised in argument before the court. If it isn't, it should have been. And if it was, and it wasn't dealt with by the court, well, then that is, frankly, an inexplicable oversight, to put it very politely. Now, the proposal for the expropriation of property without compensation has taken two legislative paths. The one that is most clearly defined at this stage is the bill published in October last year, for the amendment of the Expropriation Act. The other resides in the hands of the ad hoc parliamentary committee tasked with the formulation of the legislative method for the amendment of Section 25. I'll deal with that in a moment. We've been informed by Patricia de Lille, the responsible minister, that the proposed amendment to the Expropriation Act has been certified as constitutional by the Chief State Law Advisor. We're not privy to that opinion, but it seems obvious that the Constitutional Court will be addressed in both instances by reference only to Section 25. In this communication, in all the communications on this vexed issue, no reference has been made by any government official to the rule of law implications of the proposed expropriation of property without compensation. And yet, for anybody with any understanding of the principles of jurisprudence, the rule of law presents an insurmountable obstacle to this exercise of tyranny. There appears to be a broad consensus that Section 25 is the only obstacle in the way of the proposed legislation, and that the methods prescribed by Section 74.2, which alludes to to rights under the Bill of Rights, or amendment thereof, of the Constitution for any amendment of an article of the Bill of Rights, the way to go about this, the curtailment of the right to hold property, is that route. This is wrong. The right to hold private property is invested, and more particularly in this regard, in the rule of law. That, as Robert Vivian has already revealed, can only be amended by means of the special procedure prescribed by Section 74(1) of the Constitution. It is clear that the government has the serious intention to pursue what I call a reckless adventure, although the bill, I say, has not been finally proposed, hasn't been finally published. Now, we know that the draft 18th Amendment Bill, which I want to look at in a moment, has been published, but that the ad hoc committee that was tasked with this particular task ceased to exist and has been reinstated, and the thing seems to have come to a standstill. And I agree with Annelies, who said earlier on, that the bill itself appears to be in limbo, to such an extent that it is hard to imagine that it's going to be reinvigorated in its present form, for a variety of reasons, partly because of inertia, but also, and I think more particularly, because of something else. And as Martin has already said, Section 3A of that bill, of that much maligned bill, stipulates that national legislation must, subject to subsections 2 and 3, set out the specific circumstances where a court may determine that the amount of compensation is nil. Well, we don't know whether, as Patricia de Lille had done in her case, whether this proposed bill had ever been referred to the Chief State Law Advisor. But if it had, and if he had certified it as being constitutional, that would be an outrageous dereliction of duty on his part, on account only of this one provision. Because this one provision is more or less the equivalent of a law which is passed with the necessary 2/3, or for that matter 75% majority, which says only this. It says the principles enunciated in Section 25 of this Constitution are hereby amended to enable expropriation without compensation. Second sentence. National legislation will be passed in due course to determine to specify the circumstances under which this may be done. End of bill, end of the law, end of the enactment. Well, how can anything that is so brazenly unlawful and so brazenly unconstitutional even begin to pass muster? Now, I've given you an extreme example, but it's not much different to this, because the stipulation contained here in Section 3A of the bill, which seems to me to be in limbo, comes more or less to the same result. It comes to the result whereby a critical issue of Section 25 of the Bill of Rights is to be amended as to the circumstances under which nil compensation will be paid, but the determination of how that is to be done will be formulated in due course by the National Parliament on the basis of a simple majority. Well, this is an attempt, this is a brazen attempt, effectively, to amend the Constitution by simple, ordinary parliamentary means, by not fulfilling the requirements of the Constitution. So my impression is that bill is certainly in limbo, and if ever it is reinvigorated and brought back to life, it is most unlikely to see the light of day in its present form. Both the government's intended courses will, however, do serious damage to invested confidence and to the process of legitimate constitutional governance in South Africa. The question then is, can these be forestalled? This can only be achieved by way of an anticipatory interdict, an interdict sought before the anticipated harm eventuates. The Constitutional Court has expressed its views on such a procedure in Bob Glenister's tireless efforts to save the Scorpions, or at least to save the principle underlying that independent investigative agency. The Constitutional Court held in that case that an interdict in anticipation of a law which is about to be passed but which is not yet being passed will only be granted in the most exceptional circumstances. And the reasoning in that particular situation seems to me to be altogether plausible. For one, the bill may yet be amended. For two, the bill may be abandoned altogether. The legislative process may grind to a halt, and nothing may ever eventuate. Those are all possibilities. So it is quite obvious why the court will have said that this will only be granted in very exceptional circumstances. But I would say that where it is evident that the government is determined to press ahead, as it has done in this case with this form of legislation, and moreover, where the harm that is likely to eventuate, even from the mere publication of a bill, which specifies precisely how this is to be brought about, is likely to give rise to yet another damaging assault upon the business confidence of the country, to such an extent that one would say there are exceptional circumstances that would justify an interdict that would preclude the further action on this bill. That, to me, seems to be a perfectly plausible case to be presented before the Constitutional Court. Now, there's been some discussion about whether this is likely to succeed. Well, I don't know. It's not possible to make any predictions in this regard. And I suppose if I were to hazard a prediction, I would say, well, maybe not. Maybe it won't. Not because the case isn't a good case, not because there's not a very strong argument and a very compelling one, but because I don't have sufficient confidence in the Constitutional Court's ability to deal with a matter like this in an impartial manner in accordance with the law. The Constitutional Court has demonstrated in the past that it is inclined to deal with issues of this kind on the basis of social justice. Social justice, and not the law, is the guiding principle of the Constitutional Court. And so therefore, yes, I agree with those who express skepticism, but I don't agree that this should in any way preclude the further action that I propose in this regard. Thank you.